The topic is employment law, in an update for what's been happening in California employment law and federal law. It's an area where, more than most areas of law, it's where an ounce of prevention is really worth a pound of cure. If you've ever been involved in employment law litigation, you know that it's not a fun thing to do. It can drag on for a while, and it can end up costing a company a lot of money. So it's an area where you want to be in compliance with the law. And one of the underlying kind of background and philosophies of the presentation you're going to be hearing today from Tom Daugherty is the importance of staying in compliance, being in compliance, and not as an onerous thing, but as something that really, if you're using the laws as guidance for what you should be doing, it can help you as the management of a company really keep your labor force happier, more engaged, more focused on building the company up. So it's definitely a positive thing to be doing. And the fear of litigation is very real, certainly in California. As you all know, we've got the biggest population by far of any other state in the country. And not quite the biggest, but almost the biggest, the largest number of lawyers of any state in the country. So the combination of those things is keeping labor law a very active field, and keeping labor law litigation a very big thing. So having said that, our speaker today, Tom Daugherty, is an employment law partner with the San Diego-based law firm of Klinedinst, which is mainly focused on the Western US, and it's a fairly good sized firm. Tom focuses there on all aspects of labor law, focusing on it from the viewpoint of the employer, keeping the employer safe from litigation, helping employers understand what they need to be doing to stay in compliance with the law, what current updates to the law are, that sort of thing. And it's everything from wage and salary and wage issues, wage and hour issues, severance, other employee practices. And Tom's focus is avoiding litigation, but if litigation arises, it's coming up with the most expeditious way of handling it. And if possible, bypassing the whole process of a lengthy trial and settling the cases without having to go to trial. Tom also has a very interesting part of his background, which only one other famed speaker that I can recall in the last 10 years even came close to, but Tom took it a little further, which is Tom is a former actor. Tom's undergraduate major in college was fine arts, it was acting, and he had a career in that for a while. He's performed at the Kennedy Center, the Goodman Center, the Shakespeare Theater. And as you can guess, if you think about what's involved in acting, it's excellent preparation for a career that involves litigation and standing up in front of a judge and a jury in a courtroom and doing a presentation and doing it in a way that can be very effective. So Tom's brought that with him. Having said that, as I already said, he tries to avoid litigation wherever possible, tries to get his clients to avoid litigation. So let me turn it over to Tom. Tom, take it away.
Thank you very mumuch for the kind words there, Dan. Hi, everybody. It's great to see you all here today, and good for you for getting up early and wanting to learn a bit about employment law and the changes that have come down in California for 2022. As Dan said, I'm based here in San Diego. My law firm is, we've got 5 different offices throughout California and one up in Seattle. So we're covering the West Coast, and to our friends in Oregon, we do have an attorney that's licensed in Oregon, so we can provide help if you or your clients need it there as well. So what I'm going to do today is, hopefully make this a very useful, discussion for you and your clients. So I've got a game plan and a PowerPoint, and I've prepared, various topics. A lot of the new laws that have come down recently. We'll do a little review of some of the major ones that came down last year that were significant changes for people, as well as the new kind of cleanup laws that happened this year for going forward in 2022. And, frankly, this feels a little bit like a cleanup year. It's not got some of the dramatic changes that we've seen in the last few years, from, the Me Too movement to COVID and along with that, and now of course the AB5, will cover that a little bit, the independent contractor ABC test. It felt like California was like, all right, we need to refine and fix things a little bit, and so that's what they've done, without some of the sweeping changes we've seen in the last few years. But as Dan said, please stop me at any time, ask questions that occur to you. I may or may not know the answer, and if I don't know it off the top of my head, I don't like to shoot from the hip too much when quoting law, so I'll circle back with you afterwards and get you what you want to know. This is also intended just as general information. It's not, shouldn't be construed as direct legal advice to you in your particular situation. To do that, we need to engage in an attorney-client relationship, and which I'm happy to do offline with you. But I can't give out specific legal advice applicable to you and your clients in this format. So with that, let me get started and share my screen here. 1 second, so we can get going on the PowerPoint, and then we should be good to go. So, there. Okay, can everybody see the screen okay? You're good?
Got it. Yep.
Great, perfect. And I put my email in the chat there, so if you want to contact me offline, that's great as well. So without further ado, we will begin. There we go. Okay, so like I said, these are primarily changes that have happened in the last year, and then changes effective in 2022. We'll talk. A hot topic these days is whether employers can mandate vaccines for their workers. We'll get into some of the nuances of that, and when that can and can't apply. Of course, in California, the last many years, the minimum wage has increased each year. It has again this year, and along with that goes the exempt salary thresholds. So if you have exempt salaried employees, they need to make at least this amount, and we'll talk about that. A huge change in the law, the California Family Rights Act, formerly applicable only to employers with 50 or more employees. Last year, it was changed to apply to almost all businesses of employees with 5 or more employees, or employers with 5 or more employees. So that was a huge change. So we'll just kind of revisit some of that, and there have been some additional tweaks to that this year. A new law dealing with wage theft, increasing the penalties for that, a possible felony conviction if any employer is convicted of wage theft of their employee. Some changes to criminal background checks and what can and cannot be excluded in that. We will get into the independent contractor classification ABC test exemptions. There are some extensions on those, and then some which may or may not be applicable to you all as financial consultants and financial professionals. Some of the administrative hearings before the labor commissioners are going virtual if you want. They've joined the Zoom bandwagon like so many of us. There was formerly a prohibition in recent years on settlement agreements between an employer and employee when there was a sexual harassment claim or sexual assault claim or something like that that was resolved. Now that's been extended to all protected classes. So if there's any kind of discrimination or harassment claim based on whatever type of protected class, whether it was nationality, medical disability, age, none of those can be kept confidential anymore. The amount can, but the the facts alleged and the circumstances that led up to the dispute, that can't be kept confidential anymore. And then Cal OSHA's enforcement powers have been expanded somewhat. So if they weren't a nightmare already for employers, they are given expanded powers there. So it's been in the news a lot, and was in the news today. Just the federal mandate for vaccines. You heard about a while ago in November, this came down that employers with 100 or more employees were going to be required to mandate vaccines for their employees. That's been put on hold. There's been a lot of litigation. There are going to be oral arguments heard in the Supreme Court this Friday on this January 7th relating to this issue, whether or not private businesses must mandate that their employees get vaccinated or be tested. There have been some other challenges to the federal military or federal employee mandate. That there was just a case with the Navy in Texas today. I saw on the news, it popped up that Navy personnel that claimed religious exemption, a Texas district court judge held that they could not be required to be vaccinated. And of course, that's in the early stages, so that may go up on appeal and get a different ruling down the road, but it's certainly being disputed. But I guess the summary of this is whether there's a federal mandate or not from the government, private employers can mandate that their employees be vaccinated. Both the DFEH, the California's Department of Fair Employment and Housing, and the federal EEOC have provided guidance that employers may require their employees to be vaccinated. However, they must provide reasonable accommodations for employees that assert sincerely held religious beliefs and medical disabilities or conditions that would prevent them from being vaccinated safely with a doctor's recommendation. So what this means for employers is that if they've got an employee who's, if the employer puts out a mandatory vaccine policy, an employee comes to them and says, hey, I've got a sincerely held religious belief that says I can't be vaccinated, then the employer must engage in the interactive process and provide reasonable accommodations if it's possible. Same for medical disabilities. If an employee comes with them with claim of a medical disability or a condition that prevents them from being vaccinated, they must engage in the interactive process and provide reasonable accommodations. So, and just as a note, the standard or the threshold for meeting what is a sincerely held religious belief is very low. It's extremely low. And the courts presume that the employee will be able to meet this kind of, so there's a presumption that if an employee asserts that they have a sincerely held religious belief, that's gonna prevail. And it doesn't have to be a recognized, religion that's a mainstream religion at all. It doesn't even have to align with that employee's particular claimed religion. It just has to be a sincerely held religious belief. So as a baseline, employers would be best off to just accept that, yes, this employee has a sincerely held religious belief. And then the question is whether or not the employer can accommodate their request, because employers do have a duty to maintain a safe and healthy working environment for all their employees and for their clients and customers. And so the question is whether or not they can accommodate a person's desire or request not to be vaccinated in that workplace. And same for the medical disabilities, except there you can require a doctor's note to say, yeah, this person shouldn't be vaccinated because of a medical condition. So
Tom, a question.
Sure thing.
The reasonable accommodation, does that logic kind of roughly follow like the Americans with Disability Act reasonable accommodations?
Yeah, very
Has
closely.
It been tested legally?
What's that?
And has it been tested legally with any cases where the employer says we can't reasonably accommodate?
You know, I'm not aware of like a, precedential case where specifically a COVID accommodation has or hasn't been accepted. These are going to be case by case examples or analysis as to what the particular accommodation might or might not be reasonable for given the employer's circumstances. And you're exactly right that it is the same analysis that the courts apply when looking at American with Disabilities Act or any other kind of medical accommodation. It's the presumption is that the employer will provide a reasonable accommodation unless it places an undue burden on the employee. And so now let me kind of talk through this process. So the interactive process, all that means is you must engage in some sort of dialogue with the employee. There are no kind of magic words or magic formula for this. But when you're talking with the employee, you want to know going into it, what is this employee's essential job duties? What is required of them? If you have a written job description, that's a great starting place. And so you've got kind of an objective fact. All right, these are what we've previously determined. These job duties are required by this position. If you're not vaccinated, can we still allow that? Or are there safeguards we can take? Can you work remotely? Can you, and so you start the conversation with the employee. First, what are they asking for? Would they submit to weekly testing or twice weekly testing or, something along those lines? Could they work remotely? Could they work in a mask and, their entire time with an N95 mask or something along those lines? And so you explore both the job duties and then what accommodations are possible given the conditions and their particular position. And
Tom,
yeah.
Tom, how much do you really have to, what is a sincere religious belief? And I know it's so nebulous because, if you belong to a particular religion and they said it's okay,
Yep.
and they're saying, so it's like a personal preference versus a religious belief. And then there's other stuff where some of them are claiming, well, I can't do this, but they take other vaccines that meet the same criteria that they said is their religious belief. So can you have your cake and eat it too, I guess is what I'm saying.
Yeah, I believe that in a way you can, or employees can. I think that the courts do not want to get into judging what is a sincerely held religious belief and what is not, because it is so personal and so kind of nebulous, and it's really a very personal thing, and the courts have recognized that, and they've recognized religions or spiritual beliefs that have nothing to do with what would be considered a mainstream religion, and beliefs that don't align with any kind of professed religion. So it really, they give great deference to the employees, and yeah, you might be able to apply pressure as to whether or not they if say the employer refused the accommodation and said, look, you've gotten other vaccines in the past, or you drink alcohol or smoke tobacco, and now you're arguing you shouldn't take foreign substances into your body, then that's going to be kind of hashed out in the court if the employee sues them, and so that it ultimately maybe be for a jury to decide whether or not this was a sincerely held religious belief. But the employer's best practice is basically to accept it, but then work on whether or not they can accommodate it, and whether or not these precautions, given the deadly nature of the virus, the hazards that it places not only on other employees but their families if they bring home COVID to their family, what can happen there if they've got vulnerable people at home or whatever. So then you want to work through the possible accommodations with them. we put this person on unpaid leave for a while? Is that a reasonable accommodation? You know, and sometimes that is honestly motivation for the employee to say, okay, I'll get the vaccine because I don't want to go without pay. You know, you can do, you know, consider job restructuring, regular COVID testing, you know, definitely masking and distancing, but, you know, then it's going to be a judgment call as to what's safe enough for your work environment, given the conditions. And the employer's burden to show that this is an undue burden, the accommodation, the courts take into consideration the employer's size, their, you know, financial abilities, the nature of the work. You know, if it's a customer service work where the employee has to be interacting with the customer or has to be interacting with other employees on a regular basis, maybe social distancing just isn't going to be possible in a safe enough way, or maybe remote work isn't going to be possible because of their job duties. So there are a lot of factors that go into it, you know, definitely a case-by-case analysis. But along the way, the employers are going to be very wise to document. That's my mantra to my clients. It's like, whenever you have one of these interactions with the employees, you want to document it. What did you consider? What was said and what was concluded? Because, you know, you may have to prove it up someday. And employees typically are not documenting like that. And if the employer shows up and they've got, you know, a well-documented, in a timely way, you know, the progression of what they went through to try to accommodate the person and realize that they couldn't, that's going to hold a lot of weight and be persuasive evidence if the employee later decides to sue. So it's a process, but it's something that a lot of employers are dealing with, you know, because of the great resistance to vaccines that we see in the country today.
Question for you, Tom.
Yep.
How much probing can the employer do when there is a proposed religious belief? Can you ask them what that belief is or how that impacts their ability to get the vaccine, or is that really taboo?
I think you need to be able to establish that it is a sincerely held religious belief. So I think it's fair to say, what is the belief and how does that prevent you from being vaccinated? And so far, I have not seen cases or guidance that the employers shouldn't provide or, you know, shouldn't ask those kind of initial questions. But I also don't think that you want to get into an interrogation with the employee. I think you want to basically, you know, establish that this is something that could be considered sincerely held, a sincerely held belief, and that for whatever reason it is preventing them from getting a vaccination. And then kind of leave that as it is and move on to, you know, the interactive process and whether or not you can provide a reasonable accommodation. Because like the courts, you know, the courts have, again, shown great deference to employees asserting this, you know, defense of a reasonable held religious belief. You don't want to get into, you know, second guessing them and trying to question them as to the validity of that belief, because the courts are going to say it's valid for this person. Most likely, it's a very low threshold.
Thank you.
So, and I do advise if you come to kind of loggerheads with an employee over, you know, an employee's refusal to be vaccinated and believe that you cannot accommodate them, I would still definitely consult with legal counsel before you make that termination, because there may be ways to handle it that you're not thinking about that may save you a lawsuit down the road. Sometimes that's not going to be possible. Sometimes employers are going to sue no matter what. But if they feel offended or hurt, I tell a lot of my clients, I feel like the major source of employee lawsuits is hurt feelings. So a lot of it is the handling of the message as opposed to the message itself. So before we move on, any other questions about you know, accommodating you know, an employee that doesn't want a mandatory vaccine or weekly testing or something along those lines? Okay, great. Well, and again, feel free to shoot me an email later if you would like. So as I mentioned, the state minimum wage has gone up to now $15 an hour for employers with 26 or more employees, $14 an hour for smaller employers with 25 or fewer employees. And that knocks up the exempt annual salary threshold to $62,400 for larger employers, 26 or more employees, and $58,240 for 25 or fewer. Just a good reminder of this. And there are some different salary thresholds for computer software employees, physicians, and surgeons, but presumably you can, if you have those, I'm happy to look those up more specifically. But as a general, oh, I've gone ahead. There we go. Do remember that in certain municipalities there are different higher applicable minimum wage thresholds as compared to the state's threshold. Like here in the city of San Diego, within the geographic boundaries of the city of San Diego, for instance, it's $15 an hour no matter how many employees you have. Same with the city of Los Angeles, Malibu, Santa Monica, $15 an hour regardless of the size of the employer. And just anecdotally, I had hospitality, a hotel client doing business in and around, I had a few different locations in and around LA County and the city of LA and a few other cities in that area. And they believed that they were outside of the city of LA and within a different city. And there was a 6-month period when they were paying 50 cents less than they should have, because as it turned out, even though their mailing address said they were the city of some other city, they were in unincorporated LA County. So for 6 months, they paid 50 cents an hour less than they should have by the minimum wage. And of course, as soon as they discovered it, they paid it all back and, gladly, and said, we made a mistake. But the county came after them, and there were literally, penalties in the 6 figures because of the it was a daily accrual of penalty for each worker. So it is a nasty thing to get on the wrong side of the minimum wage requirement. So it seems like a very rote thing. Yeah, we know minimum wage is going up, but with all the different municipalities and the different areas and the differences in the amounts, it can be pretty devastating to a company if you get it wrong. So you're all number people, and you know what that means. Just important to get it right.
Have you heard of any employers who didn't want to hire that 26th employee and cross differential? Because immediately then you have to start paying everybody more money.
Yeah, that's and definitely it's not an uncommon thing for employers to be considering that sort of thing. Or does it count if we have part-time versus whole, full-time employees and all of that? And those are nuances. The best practice whenever you're near one of those thresholds is to give the employee the benefit of the doubt and pay more than you want to in the moment, because it almost always saves money in the long run, rather than facing a lawsuit for getting it wrong, or if you've got a fluctuating staff, like I had a client that they fluctuated at the time. I think it was 50 or no, I guess it was the 25, 26 deadline or line, and they were kind of up and down. So there were a few months when they were fine, and then there were a few months when they were in violation, and they were back to fine again. And so it's just if you're close, it's better to across the board pay a little more and save yourself money in the long run, I think.
And avoid those 6-figure penalties.
Yeah. That was a terror. I mean, we fortunately got to negotiate that down pretty significantly, but it still was. It was potentially a company busting move by the county. So, all right. So as I mentioned, the California Family Rights Act, the CFRA, used to be very similar to the FMLA. Now, in that it used to apply only to larger employees with 50 or more employees. Now the CFRA applies to all employers with 5 or more employees. So small businesses for the first time are having to deal with this requirement that they give up to 12 weeks of unpaid but protected leave in any 12-month period for family care and medical leave. And this applies to the employee, their spouse, domestic partner, parent, child, grandparent, grandchild, or sibling. The new law, a new kind of addition to the law this year also includes parent-in-law. So your mother-in-law, your father-in-law, or the parents of your spouse or domestic partner, that's included. And also for time to bond with a new child. So to be eligible, the employee must have worked for the employer for more than 12 months and to have worked at least 1,250 hours in that 12-month period prior to their leave. So you still count the time, but there's no longer the 50 employee threshold. It's now a 5 employee threshold. And what constitutes a serious health condition? A serious health condition, it's an illness, injury, impairment, physical or mental condition that involves either inpatient care or continuing treatment or continuing supervision by a healthcare provider. So it does have to be serious and either inpatient or continuing ongoing treatment by a healthcare provider. It can be used to bond with a new child, either by birth, adoption, foster placement, or for a qualifying exigency related to active duty or call to active duty. Now, employers, of course, can pay their employees during this leave, the CFRA leave, but they're not required to. It can be unpaid leave. Employees taking the CFRA leave are also eligible potentially for California's paid family leave and state disability insurance through the EDD. So you can check out the EDD's website if you have questions about that. Those are good programs, and their websites are actually pretty good and informative about that.
And can those things be multi-year? I mean, it says once every 12 months. So you could have somebody that could take 12 weeks every year that they work for you if it's an ongoing condition, right?
Potentially, they would have to qualify each year. So you would have to qualify and work the 1,250 hours in order to be eligible the next, year. So, but yeah, as long as they met the qualifications, if it was an ongoing chronic condition or, an issue within their family, yeah, as long as they met the qualifications, they would be eligible for it. And that is protected leave, which means you basically have to hold their place. You can, put a temporary worker in there, but when that worker is ready to come back, you've got to give them their spot again or a comparable position. So
got it.
I think
Thank
the
you.
more difficult one is when it's intermittent.
Yeah, right. That can put a real strain on, smaller employers, especially because, how do you keep somebody and maintain consistency of, the job performance, a lot of it depends on the position and the conditions, the role they're in.
Can I ask a question on comparable
sure.
position?
Sure.
What if the title's the same, but the duties are less, or they're reporting to someone with a lesser title, but you don't change their title or pay? Is that considered comparable?
That would be, like a good lawyer, I'll answer. It depends. A lot of it depends on, what, frankly, what that employee's response is to that. If they felt like they were, if their title and the pay were the same, you've got a good argument that it's comparable. But if they have significantly less responsibility, if the job is less fulfilling, they might consider it a demotion, even if the pay is the same. And you could, get into, some sort of legal dispute over that. So you want to do apples to apples to the best you can. If your, job circumstances or your company's operations change and you can't maintain that, that's another story, but it's going to be a pretty fact specific inquiry into that.
Okay, yeah, thanks. I have a specific situation I'm thinking about.
Yeah.
The person's deeply offended.
Yeah. Those can be tricky for sure. But keeping the pay the same is a pretty important one for sure. So, all right. So if they must give advance notice if when they need CFRA, if it's foreseeable, if it's an emergency, they must provide it, at least 15 days or as soon as practicable, when they realize the need is there. And employers can require medical certification for request for the leave for the employee's own health condition or to care for a family member who has a serious health condition. Now, on these, you don't want to inquire into what the specific diagnosis or specific medical condition is. This is kind of a fine line that employers need to be careful about how they tread here. They just need a certification from a physician that or healthcare provider that this patient, whether it's the employee or the employee's family member, has a serious condition that requires ongoing care or inpatient care and should be excused from work for that purpose. So you don't want to inquire as to their specific medical condition. All right, there is for under the new CFRA, under the changes, a mediation program for smaller employees. And this is a pretty niche group, but for employers with between 5 and 19 employees, there is a mandatory mediation program for disputes between employers and employees related to the CFRA leave. So if, it doesn't mean you have to reach a settlement with the employee, but you are entitled to go through this process. So if, for instance, the employee, if you refuse the leave or the employee feels that they were retaliated for taking the leave, and you fit into this category of between 5 and 19 employees, and the employee jumps right to suing the employer, files a lawsuit, the employer can put a stay on that, a hold on that, and say, look, we first got to try to mediate this through this mediation program through the CFRA. And then if it resolves, and the employer has probably saved a lot of money not going through the legal process. And if it doesn't, then litigation can continue. But it's a nice kind of stopgap against immediate litigation for these kind of disputes, especially for smaller employers. So, okay. New section of the penal code here, making intentional theft of wages, including gratuities. If you're a facility that includes tips or gratuities, if the amount of the theft of the wages is more than $950 for one employee or $2,350 for 2 or more employees in any 12-month period, that will be punishable as grand theft and can be included as a felony conviction. So, and for this purpose, for this law, independent contractors are treated as employees. So if the company engages independent contractors as well as employee, need to be careful about not doing anything that could be construed as wage theft, because it could be punishable as a felony, up to from 16 months to 2 to 3 years possibility there. So getting tough on wage theft. All right, criminal background checks. The prior law allowed for the exclusion of certain felonies from criminal background checks conducted by employers, including when that person was going to interact with children in the workplace. Now, the existing, like I said, included in these exclusions was spousal rape, and now those have been all included. The law removes the exemption for spousal rape and other felony convictions, and instead exempts only misdemeanor convictions from a notification when the employee is going to work with children. So all felonies are on the table. So that's a a change, I think, intended to make the employer more aware and the customers more aware if there's a potential criminal background issue there.
Is that a California law or a federal law?
California, yep. So, okay, so talked to Dan a little bit before this meeting, and he thought it would be good to go back through the dynamics ABC test. You'll recall in recent years, the dynamics case came out and instituted this ABC test when categorizing or classifying independent contractors from employees. And now under the code AB5 and AB 2257, all employees are presumed, or all workers are presumed to be employees, and with subject to certain exemptions that we'll get to in a second. And it is the employer's burden to show that they truly are an independent contractor by meeting each one of these the legs of this test, the ABC test. So A, B, and C all must be met, not either or, not just 2 out of the 3, but all 3 must be met. 1, the person must be free from the control and direction of the hiring entity in the performance of the work. 2, or B, the person performs work that is outside the usual course of the hiring entity's business. And C, the person is customarily engaged in an independently established trade, occupation, or business. And of course, it is on the engaging company or business to prove these things because they're the one that's going to be penalized if there's a misclassification, not the independent contractor. So it'll fall on the employer or the business to prove that and take the penalties if they get it wrong. All that said, there are certain exemptions, and there are, I think, over 100, maybe 105 specifically designated exemptions for a whole list of various professions or job types, and there are a lot of conditions that can be met and not met. Specifically talking about financial professionals, I felt there were 2 exemptions that could likely apply to allow financial professionals to engage as independent contractors as opposed to employees. Of course, financial professionals still can be engaged as employees, but there are some options for still working as an independent contractor. If the ABC test does not apply, they still have to prove that the engaging entity would still have to prove that the worker is an independent contractor under the former Borrello test, which was applicable for, I don't know, 35 years or so. I believe that it was like a 1985 case. And that was an 11-factor test. The primary factor was whether or not the entity had control over the work, the performance of the work, but there were a whole lot of other factors that were included as well. So if the ABC test doesn't apply, the Borrello test would apply to do the classification. The express exemption as far as specific professions applies to an individual who holds an active license from the state of California and is practicing as, any of these professions, including as an accountant. So a lawyer, an architect, landscape architect, engineer, private investigator, or accountant. So if you've got a license from the state of California that's active, you're working as an accountant, you can engage as an independent contractor. And like I said, there are about 105 other exemptions as well. One of one set of exemptions is the business to business exemption, exception. And this is an exception for what they call bona fide business to business contracting relationships. And these are 12 very specific requirements. This law, this is Labor Code section 2776, and it says that all of the following criteria must be satisfied in order for the business to business exception to provide. Number one, the business service provider has to be free of the control and direction of the contracting business, both in the contract, under the contract, and in fact in performance. So free from control. Two, the business service provider must provide the services to the contracting business rather than directly to the customers of that business. So, and that actually has been discussed. I saw there was one case on this point where it was a trucking case. The Truck Drivers Association was arguing that, hey, this exemption shouldn't apply because, you know, the truck drivers that are being engaged are hauling for, you know, this customer of the trucking company. And the courts kind of turned it on its head and said, no, look, you're providing services directly to the engaging company. You happen to be picking up their customer stuff, but you're providing services to the trucking company and not the customers directly. And so there's got to be some clarification on that. But because this is relatively new law, it still has a ways to trickle through the courts and get definitive answers on some of these. But that's one point where there's a little confusion, I think, as to what that means, whether you're providing services directly to the engaging company or to their customers, because it seems a little bit like splitting hairs there. You must have a written contract that specifies the payment amount, the applicable rate of pay for the services performed, and any due date when the payment will be made. So written contract's very important. If the work is being performed where a business license is required or business tax registration is required, the service provider, the supposed ICE independent contractor, must have that business license or business tax registration. So that's important for, you know, people that may be providing financial services if they're under this business to business exception. And the service provider has to maintain a separate business location, separate and apart from the engaging entity. And that can be the service provider's own home, but it just has to be, they have to have a separate business address designated separate and apart from their engaging company. The business service provider must be customarily engaged in an independently established business of the same nature as being as involved in the work performed. So it'd be good to provide that before and during, possibly for other clients. The business service provider must be free to contract with other businesses and provide the same or similar services and maintain other clientele without any restrictions from the hiring entity. The business service provider must advertise and hold itself out to the public as available to provide the same or similar services. The business service provider must provide its own tools, vehicles, equipment necessary, not including any proprietary specific materials that may be necessary to perform the services under the contract. The business service provider must be able to negotiate its own rates, and consistent with the nature of the work, the business service provider must be able to set its own hours and location for the work. And the 12th is relates to work under a contractor's state license board. So that is fairly specific, that wouldn't apply to most situations. So as long as you can meet all 12 of those requirements, you should be good to go under the business to business exception if you've got a written contract and fall under all those other requirements. So that is another way that you can still maintain independent contractor status. But again, it's going to be the business entity that's going to be hit, not the contracting service provider. So the onus is really on them to take care to make sure all those conditions are met.
Hey, Tom.
Yeah.
Dale Hill, I had a quick question on number 9. I was at a company and we provided laptops and computers because of security and data. How does that jive with number 9, and would that kind of eliminate this?
Yeah, if there are issues with security and trade secret materials and things that is necessary to perform the work, I think that kind of it sounds like that would fall under the exception there, not including proprietary materials that may be necessary to perform the services under the contract. So again, this hasn't been strictly interpreted by the courts, or even, we haven't seen a lot of even analogous, cases that might apply, but it sounds like they've kind of taken that type of thing into consideration where, you need specific, company materials to do the work to maintain their security and their trade secrets and other proprietary information, whether it's sensitive financial information or other. I think you would fall under the exception of that as far as using their equipment for that purpose.
Great, thank you.
Yep. Okay. All right. Just as a sideline, one of the changes in the law this year related to this were that, several of these exemptions were set to expire for whatever reason at the end of this year, and they've been now extended into, I believe, through the end of 2024. So I don't think they're going away, but for some reason there was a time limit set on them, and they've been extended for these various professions that are listed there. Okay, so before we move on, any questions about the ABC test or exemptions or any of the things we've talked about there?
Heard of any exemptions for staffing companies?
Yes, I don't have those off the top of my head, but there are specific exemptions for I forget if they call them staffing companies specifically, or referral agencies or something along those lines. So yeah, there are exemptions for those, and I would have to look at the specifics of your situation and that to know exactly what they are. But yes, there are some that would apply to staffing companies.
Hey, Tom.
Okay, looks like we're getting a little short on time here, so I'll try to buzz through the end of this. So like I said, the labor commissioner is now jumping on the Zoom bandwagon. These were always intended to be public hearings, and now the public can attend virtually if they want to. And if you get called before the labor commissioner or have a hearing there, you can attend through Zoom as just another convenient way to access the legal process without showing up in person and possibly contracting COVID. All right, so when there's a settlement in a dispute, whether it's a settlement agreement, a non-disparagement agreement, or severance agreement, you cannot include confidentiality for protected harassment or discrimination claims. This came down, as I mentioned at the beginning, a couple years ago, relating to claims of sexual assault, sexual harassment, or sexual or discrimination based on sex. Now that's been expanded to all of the protected classes under the Fair Employment and Housing Act, race, color, ancestry, national origin. I won't read through them all, but any protected class in California, you now cannot include a blanket confidentiality requirement on the facts relating to that dispute. So it's designed to, I believe, create more transparency so that employees are free to talk about things rather than being forced to be quiet and accept the settlement. As I mentioned, also Cal OSHA enforcement has been expanded. Now Cal OSHA may issue enterprise-wide violations where employers have more than one work site, and there is a evidence that there's an egregious, a knowing violation in multiple sites related to that. The Cal OSHA may deem a workplace egregious if, for example, the employer intentionally made no reasonable effort to eliminate a known violation, or committed willful violations that resulted in worker fatalities, a worksite catastrophe, or a larger number of injuries and illnesses, or committed willful violations resulting in persistently high rates of worker injuries and illnesses. So that, of course, an egregious designation can lead to very severe penalties, up to $134,000 per violation. So there have been some additional COVID changes, kind of unifying. There were so many different COVID laws that were passed in kind of a flurry in the last couple of years. There were some efforts made to unify them and make them more uniform, so that you didn't have different standards for different but similar events in a workplace. So there's some specifics that'll be available. I'll send this presentation out, and then you'll also be able to see it on the YouTube as well. And yeah, that's basically some additional small changes. They're required to post new orders or guidance. The California Department of Public Health is required to post on their website when they've got new guidance or new orders that come out. They have to allow for people to sign up for an employee distribution list, so you can get, updates as these new orders or guidance come out. And the Cal OSHA COVID-19 emergency temporary standards will be readopted with amendments, it looks like. And so the changes are here to stay, at least for the time being. Let's see, and there's a question here. Would providing an independent contractor with company-owned quality high video audio equipment violate the rules? Oh, Marvin, did we answer that question earlier? Is that the same? I think that, it's going to be pretty fact specific to answer that. Marvin asks, would providing an independent contractor with company-owned high-quality video audio equipment violate the tools exception for number 9? And again, I think it's going to require a pretty specific analysis of whether or not that is going to be required to, if that's proprietary equipment, to perform the work that's been contracted for. So we'll anything else I can take with you offline on that if you want to talk more specifically about that. So,
Hey, Tom,
great.
I have one other question.
Sure.
With the rise of kind of remote and hybrid work, what is the company's obligation to pay for certain things? So let's say, a lot of times smaller companies don't have phones anymore. They have the employee use their cell phone. Is there an obligation to pay for something there? And then what about like home office equipment? Like is there an obligation or legal requirement?
Sure. So most likely, yes, if the employee is required to work remotely. If there is no longer an option to work in an office or a central location, and the employer is saying, we're going to do an all remote workforce, or during this time period, because of COVID, everybody's going to work remotely, then the employer is required to reimburse the employee for all necessary and reasonable business expenses that they incur as a result of doing their job. So it's Labor Code Section 2802, and it says that the employer is responsible for reimbursing employees for all reasonable, necessary business expenses that they incur performing their job. And so if the employer says, yep, you've got to work from home, and you're going to use your personal cell phone and your own internet connection and computer, then the employer is responsible for reimbursing the employee for some portion of the cost that's incurred there. And we don't have a lot of guidance on this law, but there is one case where the court discussed the reimbursement for employee use of their personal cell phone. And the employer's argument was like, hey, they've already got an unlimited plan that they had before they started working for me. They didn't incur any extra cost because, of our requiring them to use their personal cell phones. So we shouldn't have to pay for that. And the court said, no, that's not right. The employer should not receive a windfall at the employee's expense because, you've got this requirement that they do use that. And so it doesn't matter who pays for the employee's cell phone bill, if it's someone other than the employee, and it doesn't matter if they have an unlimited plan. And so we can take that and extrapolate it to their home internet plan or their electricity bill or, utilities. It depends on how far down you want to go. But what some employers will say, you're working from home and you're using your own facilities and we're benefiting from that. So we're going to give you, X number of dollars a month as reimbursement for that. And if you don't believe that is adequate, please come to us, talk to us, and we'll work it out so that you are. So you put the onus, you provide some sort of reimbursement. You put the onus on the employee to dispute it as being, enough. And if they accept it and everybody's good, then you should have good arguments down the road. If the employee later comes back and says, "Hey, you never reimbursed me for my my water use, even though because I had to go to the kitchen and get a glass of water every couple hours, or whatever it is." It's gonna make it seem much more reasonable for the employer to have already taken those affirmative steps to reimburse, and the fact that the employee didn't dispute that amount or ask for any additional reimbursement. But yes, if the employees have to work from home, even if it's a state mandate and not an employer mandate, if the employer is benefiting from the employee working and using their own equipment and facilities, the employer should reimburse them under the law under 2802. They are responsible for reimbursing them for all business expenses. So,
got it. Thank you.
Sure.
Tom,
Right.
thank you very much.
Thank you. I
Excellent.
appreciate you having me here. This was a great group and great questions, and I'm always happy to talk offline. And if anyone has any issues that come up down the road, feel free to give me an email or shoot me a call, and we can talk through whatever. And I like to talk through employment issues with you. So
I think an overriding issue throughout this for all of us, it may or may not be possible for all of us or any of us to remember all the details of this stuff. But a critical point is to be aware of where there are issues. And if you anticipate them coming up, act in advance to be sure you're covered, to be sure you as a company are protected, and that you're looking out to be sure that you're at least trying to do the right thing by employees under the terms of the law. So again, Tom, thanks very much.